Welcome to the Lawyerist Podcast, a series of conversations about law practice. Each week, we talk with legal entrepreneurs and innovators about building a successful law practice in today's challenging and constantly changing legal market. And now, here are your hosts.
Hi, I'm Sam Glover.
And I'm Aaron Street, and this is episode 212 of the Lawyerist Podcast, part of the Legal Talk Network. Today, we're talking with Judge Stephen Dillard, the official Twitter laureate of Georgia, about the proliferation of tweeting judges and the role of courts in closing the access to justice gap.
Today's podcast is brought to you by Podium, Gusto, and Casetext. We wouldn't be able to do this show without their support. Stay tuned. We'll tell you more about them later on.
So Judge Dillard was an early-ish guest on the podcast a couple of years ago, talking about similar topics, but we love having him on and getting to know him better, so we thought it'd be fun to bring him back. And I'm really enthusiastic about the things he has done to encourage judges to participate in social media in appropriate ways to kind of democratize access to judges and the court system and how that plays somewhat in his access.
It sounds like there's a but coming.
But having more episodes about Twitter feels gross to me personally, and I'm wearing my speaking only for myself, not on behalf of the company hat right now, which is like, I hate Twitter, and I think it is everything that is wrong with the internet and society right now.
I mean, I don't disagree. I think Twitter is maybe a bit of a red herring, just because I think Facebook shares most of the same problems in different ways. But yeah, I mean, the way social media encourages you to say provocative things and unthoughtful, unnuanced things and takes sides and pushes people to extremes it doesn't encourage engagement and interaction and empathy. It encourages just like sniping.
And mob mentality and cliquishness in a way that isn't about building community, but is more on the exclusive rather than inclusive side, and how it polarizes people and how it like flame wars and troll wars and all this shit. Like, it's gross to me.
Yeah, so like I have this conflict because I think a lot about trying to subtract social media from my life. I would love to delete my Facebook account and never go back to Twitter. And God, LinkedIn is pointless and I wish I could just get away from it entirely. But I can't for a variety of reasons, some of which have to do with the fact that our business has interests in being able to use those platforms to promote things or to engage with our community. And like I couldn't even organize, my kid's Girl Scout troop is organized through Facebook. And we stay in touch with other parents at school through Facebook. And I don't know how to replicate that anywhere else.
Yep. I don't think there's a good answer.
There isn't a good answer, but it feels like a big problem we need to figure out.
And Lawyerists, to be clear, Lawyerists' official company position is if you want to engage with us on Twitter, we are happy to chat and interact with you, and you should absolutely follow Lawyerist on Twitter. Yeah. I will probably even check in every once in a while and like some things, but that's about it.
And I do, because I also have great conversations on Twitter. Like, it'll be last week by the time this podcast airs. I've had a great conversation with a number of people, including one of our very recent podcast guests, Kat Moon, and a bunch of other podcast guests, about the state of legal conferences and innovation and what needs to happen. And they were good, and they involved some nuance and some productive conversations, none of which was toxic or polarizing. And those things happen, and maybe they redeem it a bit.
There's no question that there are great uses for Twitter and that some people are able to find lots of value from it. I don't dispute that at all. There are some people who love it and need it and build their days around it. The tool itself, though, is breaking everything around us.
Yeah, no, it's bad for society. But to bring it back, the way in which Judge Dillard uses it is one of those examples of how it can be used really well for public outreach. And so I'm going to let him talk about that. And we're going to talk about the proliferation of judges on Twitter right after a brief sponsored conversation with Casetext. Stay tuned.
Hey, I am Jake Heller, the co-founder and CEO of Casetext. Casetext is a legal research website that uses artificial intelligence to help you research faster, more affordably, and more efficiently than you likely are right now. And what we're talking about today is about artificial intelligence.
Oh, I love talking about AI and robots.
Oh, yeah.
So, Jake, tell us about the robots that are coming for our jobs.
Well, I mean, that's the thing, right? So artificial intelligence, I think, is greatly misunderstood. And ever since we started working on artificial intelligence, we've been getting so many questions from lawyers that I think demonstrates there's a lot of confusion. And so point number one, confusion point number one is there are no robots coming for your job, at least not probably in our lifetimes. And the reality is that most aspects of legal practice require a uniquely human intellect, judgment about what to do or not to do. What is, going to be persuasive in a brief, developing clients, robots aren't going to go golfing with the clients for us, right? All of these things are ultimately human tasks.
Yeah.
So the question is really what is artificial intelligence actually, and what can it even really do for my practice if it's not going to completely replace everything, right?
Yeah, do you have some good examples? Bring us back from the sci-fi, all-powerful super AIs and talk about how it's actually operating to benefit people and lawyers now.
Totally. So at a high level, what artificial intelligence even is, and that will help explain what it can do for you. What it is simply a mechanical technology process that emulates one piece of human intelligence, right? So, for example, being able to understand voice and language is one great example of artificial intelligence, or being able to pick up a pattern from a bunch of data is another great example of artificial intelligence.
Or what Kara does, Casetext AI, which is read a brief for you and help you understand the patterns of legal issues in the brief, right?
Yeah, that's exactly right. So a few examples of this, one of our technologies, Kara, is a technology where you literally just drag and drop in a brief or complaint, and it will come back to you very quickly with research ideas about what you need to be researching next. It is using both the piece of human intelligence that is understanding language and also looking for patterns, for example, the patterns in your citations to see, and what other people have cited to see what you should cite to next.
Yeah.
And the other examples might include e-discovery, where it might suggest, the next document to review being more relevant than the last, reviewing contracts and seeing what kind of sticks out. And other aspects of legal research are all impacted by these aspects of artificial intelligence. And it's making a real impact in a lot of people's practices today. So besides the sci-fi is going to take over all of our jobs, it actually might be helping you already today doing one of these things. You may not even know it's artificial intelligence.
So, Jake, you're trying to sell artificial intelligence, so that's why you're excited about it. I'm excited about artificial intelligence because the possibilities to make the world a better place are amazing. What do you say to lawyers who are like, things are going fine right now. I like my law library. I like my old school legal research solution. Why try new things? I don't want to change.
I think that at the end of the day, the real reason to change is that it will make you a better practitioner.
Yeah.
And that's because what the machine is doing sometimes are things that a person or even group of people cannot do that effectively. So, for example, it might help you unsurface precedent that you may have otherwise missed while doing legal research. It may help you unsurface a key document in e-discovery that you would otherwise totally miss, right?
Yeah.
And by the way, it's doing all of this, and it may help you do this way faster. So instead of, for example, charging by the hour, if you have clients who care about this kind of stuff, you can say, I know for a fact that with AI, my research will only take me 2 hours instead of 10. And as a result, I can change the way that I interact with my clients. Right. So, whether it be being more efficient, finding things you would otherwise miss, or pricing more predictably, it can put you in a position to be an all-around better practitioner. And I think for that reason, it's worth checking out.
Well, and I guess fundamentally, if you aren't trying to improve the legal service that you give your clients, if you're not trying to improve your practice of law or the practice of law, if you're not trying to make the world a better place in those small ways, then what is your goal as a person who runs a business and a law practice? And so
I think it's right.
I mean, hopefully, why try new things? The answer should be because you can make things better. And that should be enough, I hope.
Yes, I hope so too.
If you'd like to learn more about Casetext and making the world a better place through artificial intelligence in at least one small way that could have a big impact on your practice and your client service, go to casetext.com/lawyerist. You can get a 14-day free trial and see how Casetext and Kara work. And exclusive for our listeners, you can get 15% off once again by visiting casetext.com/lawyerist. Thanks so much, Jake.
Thank you. Great to be with you.
My name is Stephen Dillard. I'm the Chief Judge of the Court of Appeals of Georgia.
Welcome back to the podcast, Judge Dillard. It's great to have you back.
Great to be back.
And just like last time, I am not going to call you Your Honor all the time, even though the litigator in me wants to.
That's quite all right. That's okay. We're not in a court. It's perfectly fine.
So congratulations. I saw you just started your second full term at the Georgia Court of Appeals. That's awesome.
That's correct. Thank you. I appreciate it. It's always nice to get validation from the people you serve.
How many years in are you now?
So I just hit the 8-year mark back in November.
Mm-hmm.
So I just started my second full term, and that will go through the end of 2024. We have 6-year terms.
So for the benefit of any other appellate judges listening, what do you know about being an appellate judge now that you wish you knew on the day you first donned your robes?
That's a great question. I think here's the big thing. You know, I thankfully I spent 2 years clerking for Judge Daniel Mannion on the United States Court of Appeals for the Seventh Circuit. So in terms of kind of understanding how an intermediate appellate court operates and how a judge in that, I don't know that I could have had a better model. The one thing that is a little bit different, at least on the state side, and is, I think, a positive byproduct of having judges who are directly accountable to the people through elections, I don't think I understood how much time the ceremonial aspect of the job would require. Really? And it is considerably more than, I think, federal judges. I know that federal judges give speeches. I know they go to conferences. But, a lot of my time as a state intermediate appellate judge is spent speaking to civic groups, speaking to at CLEs. I spend a lot of time speaking to folks, hosting people at the Court of Appeals, speaking to students, doing high school mock trial. And these are all things I love, by the way.
Right.
But it does take a lot of time. And so I think the one thing I would warn folks who are becoming state appellate judges is that, there's going to be a lot of ceremonial things that you're going to do, and you're going to enjoy them. But then that means on the weekend, sometimes you're playing catch up with your work.
And it sounds like those have the double purpose of you're doing them on the one hand to, open up the court system, educate people,
right.
Service to the bar and to the public, but it also gets your name out there and helps you get reelected.
It's good politics. I mean, I think, I always like to say doing the right thing is always good politics.
There you go.
So I think it is important for judges to be out there and to be accessible to the people we serve. And like I said, I enjoy it. I love speaking to lawyers or non-lawyers, and I love especially when they bring in student groups. That's probably one of my favorite things. I love swearing in new lawyers. I mean, all of those things. It can be a tough profession, and we have a lot of cases that deal with very, with heavy subject matter. So It's nice to be able to do those things as a judge. And you always have to remember, you may be doing a lot of these things. That person coming before you, whether it's a swearing in ceremony or whether it's a student group, you'll never know what kind of impact you can have in those few moments with each person that you meet. And so I try to always keep that in the back of my mind.
That makes me think about something that I've wondered about a bit, which is how isolating is it to be a judge? Because I feel like it is different than being a congressperson or state or federal representative or even a governor or an executive, other kind of executive. Like a judge is an intimidating thing for people to get their heads around, and it feels like it might end up being a little weird even for your old friends to sit down and have a drink with you. And once you become something so significant, I don't know. I've wondered about that, if it's isolating or not.
I think it can be. I think you can make it less isolating. I mean, one of the reasons that I do social media and one of the reasons that I try to do little things like not wear ties when I go to functions. And I want to do everything I can to appear more approachable. I've said this a lot. When I was coming up as a lawyer, you'd go to some of these bar events, and that was usually the time where you would see a judge. And it was intimidating. I mean, they usually had gray hair. They were considerably older. They were almost these mythical figures. And I know that's how it was coming up. And when I became a judge, I just decided I was going to do things differently. And I'm not saying my approach, well, I do think it's better. I will say I think it's better. I made a decision that when I became a judge, that I was going to do everything in my power to be more accessible because I think it's important for judges to educate and mentor and be engaged with not only lawyers and law students, but the people we serve. I mean, at the end of the day, judges are public servants. We're accountable to the people. And I think for a while we got it in our heads that judges, they wear these black robes, they sit up on the bench, and they really, that we want them separated in a way from the public. But I think there's the harm there. I think that when judges become so far removed from the people they serve, I think it can impact how you do your job. And so I've just taken a different approach. And I know there are some people that don't agree with that. They think that it's beneath the dignity of the court for a judge to be on Twitter, to be on social media platforms, to be as engaged as I am and doing other things in real life, going to speeches, doing high school mock trial, and being as visible as I am. I just respectfully disagree. I think that judges who do that, who are more accessible, as long as they're not doing anything online that they, wouldn't do. I mean, as long as you're not doing anything online that you wouldn't also do in public. Right. I mean, it's all about using good judgment. At the end of the day, whether you're online or in real life, you should use good judgment. And I think if you're promoting professionalism, if you're promoting civility, if you're promoting access to the courts, if you're doing all of those things, I don't see how that's harmful.
Well, I suppose if a judge has difficulty exercising good judgment, then maybe we've got a problem.
Well, but one of the things I point out in this article I wrote for Judicature, this publication by Duke University, is I said there is some benefit. I mean, if there's a judge who is on social media and they're doing things that are inappropriate, it's going to be noticed. And maybe that's a good thing. Maybe we catch them doing it. And maybe if they're doing it online, if they're engaging in poor judgment online, they're probably doing it in real life. And there is a certain, kind of bringing things to the daylight, right? Bringing things to the public's notice. I don't think that's necessarily a bad thing. Let's use those examples, and then maybe they need to be removed from office or disciplined in a way that'll make them a better judge. So yes, there are pitfalls for judges using social media, but at the end of the day, I don't think that in and of itself is a reason for judges not to use social media.
Well, the first time we spoke was you and Judge Willett, and I think one of your colleagues, maybe Judge Wright, if I'm remembering right, had just joined Twitter.
Judge McMillan, I think. Maybe that's McMillan right. may have been on Twitter at that point.
And since then, there has been kind of an explosion of maybe that's overstating it, but it feels like there are a lot more judges on Twitter than there were when we just talked a couple years ago. That seems like right in line with what you're saying. And I guess what I was thinking about it is it does take judges from that inaccessible position where it's really just, it almost felt like a few privileged, well-established lawyers would get to know them and golf with them, and almost nobody else ever got to spend any time outside of a courtroom with a judge. And that's probably overstating it too, but I guess I personally think it's amazing that judges can be more accessible to the public. And I guess maybe that's where the Twitter Laureate of Georgia award comes in. What's that all about?
Well, so a good friend of mine, Representative Scott Holcomb, he approached me about it, and I can't remember how it came up. I think it all started, of course, with my good friend Don Willett, who was recognized as, I think he was in Texas, they called it the Tweeter Laureate, and that may actually be the more appropriate title. But in any event, I can't remember how it happened, but he and I were joking around about it. And he was like, I'm going to get this done for you. And I said, I just kind of laughed it off. And I was like, okay, all right. And then, next thing I know, fast forward a year later, he sends me a message through a direct message on Twitter. He's like, hey, I hope you like it. And he sends me a link. And sure enough, he's gotten all these co-sponsors. And the thing that I loved about it was bipartisan. There were Democrats and Republicans. And the purpose of it, I think, is really more, I hope, and I think it's bigger than just me being given a recognition. I hope what it does is encourages not only judges, but public officials in general to really work at using social media in a positive way. And they were recognizing me because of my efforts to promote civility, to promote professionalism, to promote transparency with regard to Georgia's appellate courts. And, and I think also to show a human side that judges, one of my colleagues who's used to be on the Court of Appeal, he's now on the Supreme Court of Georgia, John Ellington, used to say, there's life outside the courtroom, go and get one. Don't be so consumed with your job being a lawyer or a judge that you fail to kind of live life. And so one of the things I try to do with my Twitter account, and I think people who know me in real life will tell you this, who follow me on Twitter and know me, that my Twitter is a pretty accurate reflection of who I am. Now, it probably doesn't show, obviously you put your best foot forward on social media. I'm not, by no means am I perfect. I have plenty of faults, and maybe those aren't always coming, you can be short with your kids or your wife, or you can get into disagreements, or maybe you're not as charitable with one of your friends as you ought to be. But I think in terms of getting a sense of who I am as a person, Twitter does a pretty good job of that in terms of my interests, my passions, the things I care about. I don't obviously talk about partisan politics or what my views are on policy matters, and rightly so. I want to be a judge that no matter what someone's background is or what their, preferred policy preferences are, that when they come before me, they know that I'm going to put aside my personal views and I'm going to follow the law. And I want them to have confidence in that. So I keep it light.
Yep.
I talk about music, sports. I will talk about, in general, the law, no specific issues, but I'll talk about, oral argument tips, brief writing tips. I'll talk about the history of the Georgia Court of Appeals, our inner workings, our culture. I mean, those are just a few topics that we'll address. And I try to keep it light. I mean, I try to be careful even with humor. And I think, once again, it's using the same judgment that you would use in real life on a social media platform. It shouldn't be radically different. The big difference is if there's a misstep, you can go viral much quicker. But, even that's changing, Sam, because the truth is, even if you're not on social media, if you give a speech to a group,
doesn't mean you're going to be on social media. Yeah.
you can bet that if you say something, so the question becomes, I would rather be out there and have a reputation with folks. And if somebody tries to take something I've said out of context, then at least having been accessible and being available to the public, I think it's almost a defense in a way of someone taking you out of context. At least the initial reaction to it might be that's got to be taken out of context.
You might get the benefit of the doubt, or
that's not in line with it. So I think pretty soon it's not going to matter whether you're on social media. The question is, are you going to go out and are you going to be out there and be visible in public? Or are you going to let someone else do it for you at some point? Unless you're just going to hide, in the courthouse and never appear in public. And I just don't think. I think even for federal judges, that's unlikely. Even federal judges give speeches and are available every once in a while. Although much less so than state judges.
Well, we need to take a quick break to hear from our sponsors. And when we come back, I want to pivot and talk about the role of courts in closing the access to justice gap. So we'll be right back.
Legal research is too expensive, hard to use, and time-consuming. It doesn't have to be. With Casetext, you can save $2,000 and 210 hours on legal research this year. Casetext has unique artificial intelligence technology that does a lot of the research for you. Just drag and drop a complaint or brief, and you'll quickly find cases on the same facts, legal issues, and jurisdiction. Casetext is fast, well-designed, and comprehensive, and it's very affordable. Go to casetext.com/lawyerist to get Casetext for $55 a month. Casetext is modern legal research trusted by over 3,000 small firms and 40 firms in the AmLaw 200. Go to casetext.com/lawyerist to get started. If you have a small business or know someone who does, you probably know that small business owners wear a lot of hats, and some of those hats are totally great. But some, like filing taxes and running payroll, for example, are not so great. That's where Gusto comes in. Gusto makes payroll, taxes, and HR easy for small businesses. Fast, simple payroll processing, benefits, and expert HR support all in one place. Gusto automatically pays and files your federal, state, and local taxes so you don't have to worry about it. Plus, they make it easy to add on health benefits and even 401ks for your team. Those old school, clunky payroll providers just weren't built for the way modern small businesses work, but Gusto is, so let them wear one of your many hats. You have better things to do. Listeners get 3 months free when they run their first payroll. Try a demo and see for yourself at gusto.com/lawyerist. That's gusto.com/lawyerist. In business, reputation is everything. And while online reviews can make or break you, your best clients probably aren't showing up. And that's too bad, because if they did, you'd have more clients, more referrals, and be the top-rated law firm in your area. If you're tired of waiting for reviews to trickle in, you have a choice. Either keep waiting or get proactive with Podium. Podium helps you get more reviews on the sites that matter most. Use their messaging platform to give friendly reminders while sending clients straight to the review sites that you care about the most. With Podium's built-in analytics, you can set goals, monitor progress, and incentivize your team to reach out to more clients. Become the #1 choice online. Visit podium.com/lawyerist to save 10% when you start. That's podium.com/lawyerist to get started and save 10%.
So we're back. Judge Dillard, I have been known to say that it's pretty hard to imagine anything being truly disruptive in the law because it is slow-moving by nature, and that's probably not a bad thing. But the one part of the legal system that I think could truly be disruptive is the court system, because they're the one part of the system that can just bang a gavel and change everything. For example, in my own practice, which it's been a while since I actively did it, I dealt with debt collection. I sued debt collectors. I defended people sued by debt collectors, and I was dismayed at the volume of the court's business that was taken up by effectively rubber stamping requests to garnish wages and things like that. And I dreamed about the courts just saying, requiring debt collectors to submit a form that verified that they had all of the proof together before they got to go garnish somebody's wages. And I realized that some judges are like, ooh, that's pretty activist. But another example that I could think of is the courts taking their self-help desks another step further and having official forms that people can fill out online to get business done at the courts. It feels like that could make just a massive difference to accessibility. And I'm wondering how you react to that and how you think about what courts are doing and how you might think about the role that courts could play in making it easier for people to use them.
Well, let me answer it.
It's a massive question I just posed you, but
sure. So let me say that first of all, I think, having been chief judge and worked closely with our clerk of court, I can tell you we're very concerned about kind of what I would call point of service.
Yeah.
We're concerned about, and I'll give you some examples. We have on our website a citizen's guide that in plain English talks about different aspects of the appellate process. And that is primarily meant for people that are pro se and representing themselves, going over things like what the standard of review is, what that means. And we spent an entire summer having some really bright interns do an initial draft, vetting it through our clerk, sending it to the judges, letting us look at it, and approving it before it went on the website. So that's just one way that we try to be proactive in terms of dealing with the public. Another accommodation that we've made is that sometimes we have lawyers that are pro hoc and they have to get admitted quickly. And normally in the past, for most courts, you have to be in person to take the oath. We decided to do that, allow it by telephone in certain circumstances. We wanted to do that because we recognize that not everybody can get there. And we, once again, it doesn't really make sense to have some lawyer who might have to charge their client to come get sworn in, or they can't bill it, and that's just wasting time, especially in a massive state like Georgia, where, you've got Savannah, 4.5 hours away from Atlanta. We also, I think I mentioned this last time, we I don't know if we were live streaming, but since I think you and I last talked, our court is now live streaming oral arguments, which is once again provide that anybody, not just lawyers, they're accessible to anybody, and we archive those arguments, which I think is important from a transparency standpoint.
I think you were just getting ready to go live with that last time we spoke.
Right, and so we got the funding, and I'm very thankful to the Georgia legislature for going on and allowing us to do that. We're getting ready to move into a new courthouse, and they could have just said, well, let's just wait until 3 or 4 years until you get in. And they were like, no, we agree with you. This is a matter of transparency, and the Supreme Court was already doing it. So that's another way that we do it. But we have a lot of things on our website that I think we started a Twitter account to let people know when when we're going to be closed, or there's all sorts of things. I mean, some of these are access to justice related, and a lot of our filings are now electronic. We're looking at ways to reduce or eliminate fees for people representing indigent individuals. I mean, we are constantly reevaluating whether what we're doing is hindering access to justice for the most vulnerable citizens in Georgia. And, we also still take some paper filings because,
Sure.
Quite frankly, prisoners don't always have, sometimes they have access to computers, but a lot of times they don't. And so obviously we're going to make exceptions there. So I think what I would say is the Georgia Court of Appeals, and I think I could say this for the Supreme Court of Georgia as well, is we aren't just banging a gavel. And the nice thing is we coordinate with our Supreme Court on our rules and how we operate, and we let them know if we're doing something different or if we're looking at doing something different. They coordinate with us. And then we have the Judicial Council, which I currently serve on, where you have representatives from each class of courts, and we're currently working kind of collectively to come up with an e-filing portal system where no matter, where it won't be like Pacer necessarily, but it'll be a one-stop shopping where Georgia lawyers can go and file something. So we're moving toward, I don't know if that's so much an access to justice, but there obviously would be some implications from that. But I say all that to say we are working together collectively as a judiciary in Georgia, and we're talking these things through. We're not doing anything on a whim or without thinking about the implications of making those kinds of changes, because, and that goes to your point, is that the law moves slowly. We took a while even just implementing live streaming to make sure that we were doing it the right way. And so I think, even when that decision comes out, it's usually there's been a lot of deliberation, a lot of eyes, and a lot of different points of view that have led up to that. And I think even once you've made a decision that may be disruptive or that may change the status quo, that's not necessarily a bad thing. It may improve things. And you have to be willing, I think, to constantly – that's one of the things I try to encourage at the Court of Appeals is if somebody's got a better way of doing something, I want to hear, whether it's internal or external, I want to hear that so that we can improve. I think you should constantly be reevaluating your processes and things you do to make sure that you're being as efficient as possible while not sacrificing kind of the quality of review in your work product.
So I'm going to ask you a question that maybe is a little unfair because you're an appellate judge, not a district court judge.
Sure.
But one of the criticisms commonly leveled at the legal system is that it's designed for lawyers when lawyers are actually the minority users of the system.
Right.
Right. Like in family court, for example, 70% of litigants are unrepresented, but everyone goes about their business as if it's lawyers and judges and clients rather than just people approaching, standing in front of the courtroom. And, I've noticed sometimes things get tense when there's a pro se person in the courtroom who doesn't seem to know what they're doing, which nobody does because it's complicated and it's not really designed for them. And I'm wondering if you have a sense for sort of an awareness on the part of courts that courts are not designed for pro se folks and a willingness to try and figure out how to make that shift so that regular folks can use the courts as much as they are, but with a lot less difficulty. I don't know. And again, that may be an unfair question for an appellate judge. I don't know.
Well, obviously we do get a lot of pro se appeals and, we look carefully at everything, but my instructions are always to treat the pro se appeals as seriously as we treat a brief from King and Spalding, that, and it's not unusual for me to rule in favor of a pro se party. And sometimes that means maybe expanding, a lot. You'd be surprised at how good some of them are. I've been
not necessarily. I've watched some good ones.
I've been really impressed. Now, some of them are obviously, you've got folks that just don't have the expertise, but even sometimes when they're stumbling along, they stumble across a valid issue. So we treat, all I can say from my chambers is we treat those appeals very seriously. I think beyond that, I've talked to a lot of judges at the trial level, and especially in the family law context. It is my understanding that there are a lot of efforts that are made to provide information when people come to the court and say, hey, we want to do an uncontested divorce. They have packets available that are in plain English that try to walk them through that process. So I do, my sense, although I've never served as a trial judge, my sense is that there are efforts to provide, much like we have on our website, as I mentioned, a citizen's guide. My sense is that is going on in a lot of trial courts in Georgia. I mean, I don't want to misrepresent anything, but I'm in my head, I'm remembering conversations from judicial council meetings where I feel like at every level there's a real effort and an understanding that you're right. A lot of the people that appear in court are self-represented. They are proceeding pro se. And I do think there's a sensitivity, at least in our state, to trying to ensure that these folks know the process and understand their rights and to kind of bend over backwards. Now, you can wear out your welcome, right? I mean, you can,
Yeah.
if you are constantly filing frivolous appeals, or you're constantly, at a certain point, you do wear out your welcome, and there are measures and things that courts can do to deal with that. But my sense is that there are efforts, kind of ongoing efforts, to educate the people that are proceeding pro se and to help them out and to give them guidelines, especially in areas like family law where they're dealing. It's easier for them to have something in place to give those folks and to kind of help them along the way than it is to simply deal with it on a case-by-case basis. When you can put something out, whether it's something online on the website or something I hand out that will answer most of the questions rather than having to field those phone calls. So I think there's some incentive. I don't know that answers your question, but that's
I guess I'm just sort of ruminating. The legal system is a system designed to be used by expert users,
right.
But it turns out that most of the users, the vast majority of the users of the legal system, are not expert users. And I wonder is it even, a lot of people, me included, sometimes like to talk about ways that we think the system could be reworked so that it isn't a system for expert users, but it's a system for everyday users. And I'm wondering if that just feels fundamentally impractical. I don't know.
I mean, I think there's constantly, there are always things we can do to improve the system and to make it more accessible to the people we serve. Quite frankly, that's another reason. I mean, part of it's a confidence thing, right? I mean, people have to have confidence
right.
that the judges and the courts they go before are, care about the people that appear before them. And some of that is going out and speaking to groups that aren't just lawyers and judges, which is another reason why I think having judges on social media and having people who aren't lawyers who see that judges are human beings and that they're doing their best to serve the public. I think there's a certain amount of confidence that comes from that, with judges kind of being out in the open rather than cloistered away, at the courthouse. And so I know that doesn't directly address what you're talking about, but my sense is that judges, whether they're at the trial level or the appellate level, at least in the state system, at least in our system, that is a concern. And I do get the sense that there is a push to, accommodate and to educate those folks when they're starting their journey, when they first walk into the courthouse.
Mm-hmm.
I think there are a lot of Georgia courts, whether it's, for example, the probate court, right? I mean, in Georgia, in some towns, the probate court doesn't even have a real lawyer as a judge. It's just a citizen. And that shocks people when I, tell them that. In areas of Georgia over 100,000 people, I think it's 100,000, you have to have, now some of the smaller areas do have lawyers as judges, but I'm pretty sure in a lot of probate courts there are certain citizen guides. In magistrate court, there's certain that kind of walk you through the process of filing now, does that answer all of the issues that you're talking about? I don't think so, but I think we're getting there, and I think, quite frankly, I think there's more of a demand. I think that people, my age and younger, are demanding more accountability from the judicial branch, and they're demanding more customer service in the sense that it needs to be more accessible, and there needs to be an understanding by the judicial branch that the vast majority of people that are coming through the system are not represented by lawyers.
Yeah.
So I think you're right to raise the question. I don't know that I have all the answers, but I can tell you from our perspective at the Court of Appeals, we are trying as best we can to be accessible to everyone and to make it as easy as possible to practice before our court, whether or not you're represented by a lawyer or whether you're pro se.
Well, that's good to hear. Switching gears a little bit and going backwards a little bit, do you have a sense for how many judges are on Twitter now? I just thought since you were one of the early judges on Twitter, you might have taken note of that.
There are a lot now. And I know there are several appellate judges, state Supreme Court justices, state intermediate appellate judges. There's a lot of trial judges. There's a lot that are on Twitter. The level of engagement, I think, varies from judge to judge. Bridget McCormick, the Michigan Supreme Court, is very active, and I think she's doing a great job with her account. There's just a lot. Judge Carla McMillan from my court. I know Justice Bethel on the Georgia Supreme Court. He's on Twitter. Brian Rickman on my court is on Twitter. Judge Gobeil.
It does seem like there are some who violated the golden rule and tried to be anonymous and talk about their cases as well, which is the exception rather than the rule. But it's interesting that I was looking this up, and it looks like some judges have gotten into a little bit of hot water for talking about the people who've appeared in front of them.
Yeah, that's bad. I mean,
that's the golden rule,
that.
Don't talk about your cases.
Yeah, you don't talk about your. That's the number one rule. Don't talk about anything. Certainly not anything specific. Now, if you want to say, in the last year, I've been really impressed with the level of advocacy of the lawyers who've appeared before me. I think that's perfectly fine. I don't think, or I've been in the last year, I've been really impressed with the how well written most of the. Talking in generalities, right, I think is absolutely fine. But talking about something that happened at oral argument that day, or commenting on someone's appearance, or commenting on, wow, that lawyer did a poor job before me today. No, you don't do that. It's very bad form. You don't comment on, once again, you stay away from partisan politics. You have to watch out. Even the most benign tweet can be taken out of context depending on the timing of the tweet. And so some days when things are running really hot, I'll just stay off Twitter for a while.
Well, I was wondering, is there a tweet that you wish you could take back?
I don't think so. I remember there was one, and I don't remember all the circumstances behind it, but all I did was quote an article. And I always quote the title of articles to make it clear that that's not my title. And there was something where I did that, and I don't even remember what it was about now, but somebody got real offended. And I was like, I do that with every tweet. And I just thought to myself, well, this just shows me that you have to be, and this was early on. This was before I had a lot of followers. But look, if people want to be offended, if people want to try to take what you're saying out of context, that can happen. There's always that danger, but that can happen in real life too. And
you have sparked some hot debates around the Oxford comma and spaces between sentences and whether or not citations ought to be in footnotes.
And I'm okay with that kind of controversy.
Those are hills you will die on.
I call that kind of nerdy controversy, but it's not politics, right? And I think those are healthy debates. I think those may be debates that only appellate nerds and law nerds really care about, but I think it's perfectly fine for a judge to, have that kind of debate and to let practitioners see that there's some judges, because, I'm in the minority view on what I call team footnotes, right? I mean, not a lot of judges. And so I kind of feel like because I've got my platform, it gives me an ability to say, here's why I do it the way that I do it. I'm not really trying to get converts so much as I'm trying to defend. And I got to tell you, I have a lot of lawyers come up to me, and of course, I understand some of them have an incentive, but it seems genuine. A lot of them come up and say your opinions are they're very readable because they don't have this clutter in there. And so, I don't agree. People are like, oh, you disagree with Brian Garner. Well, not really. I mean, Brian doesn't like substantive footnotes. He likes citations and footnotes. Scalia liked substantive footnotes, but he didn't like citations. I kind of combined the two and went all in on footnotes. And so it's my own unique style. And that's the way and the big thing I tell lawyers and law students is you need to develop your own writing voice over time and your own writing style over time. And that's what I've tried to do. And I'm never fully satisfied with anything I write. I think once you start becoming satisfied or complacent with your writing style, you're on a downward trajectory. I always want to strive to become a better writer, and I think there's always room for improvement no matter what level you're at.
Well, speaking of which, I've got two final questions for you. And the first is, what advice would you give to a lawyer fairly recently out of law school who's drafting their first brief, whether it's to a summary judgment brief or a brief to a court of appeals? What's the biggest thing that you can offer them to help point them in the right direction?
Well, I think, first of all, there's internal considerations and external considerations. The internal considerations you might want to review if you're doing it for a partner. You might want to see some prior filings just to get a sense of that partner's voice and how he or she likes to write. As far as the external considerations, filing it with us, my big thing is don't use legalese. Provide a roadmap at the beginning of the brief. Give us a summary of the argument. Don't neglect your facts section. Use that as an opportunity to frame your kind of overarching narrative at the outset. Don't spend a ton of time, don't spend 3 pages on the standard of review for summary judgment. I know what the standard review is. Put it in a couple of lines and move on. And don't spend 10 pages going over and summarizing cases and the facts of those cases that really don't have anything to do with the facts of your particular appeal. Sometimes people do that to extract a principle of law from 10 cases, and they just go on and on to, I mean,
keep an eye on where you're going, right?
Yeah. Keep an eye on where you're going. And, anything that does not add subtracts from your opinion. You need to be ruthless in cutting things out of the opinion. You don't have to max out your pages, right? Just because we give you 30 pages or because we give you whatever it is, 15,000 words or, whatever it is on the word count, you don't have to use all of that.
And in fact, the judge may be grateful if you don't.
Yeah. And use a big font, definitely use 14 if you're in Times New Roman so I can actually see it. My poor eyes are getting, every year I have a thicker lens when I
believe you're a fan of Georgia as an alternative to Times New Roman, though?
I like Georgia a lot, not just because of the name. I like the way it looks. But there are plenty of fonts. Right. Times, I'm not like some people. I'm not a hater on Times New Roman. But our opinions, I mean, our court uses that for our opinions. I don't love it, but, I mean, it's not like it's Courier, right? I mean, Courier is the worst.
I appreciate your scorn.
Do not use Courier.
Speaking of pressing issues of the day, how do you pronounce the graphics interchange format or GIF? Is it GIF or GIF?
I would have thought it was GIF, but everything I've heard is that the guy who created it says it's GIF. I don't really care. Do you think
he gets to say that, though?
I don't know. I mean, I don't really. I don't feel real passionate about that one way or the other. I've gotten to where I say GIF, but I could easily go the other way on that. That's not.
I was hoping to get a final judgment on that, since I was giving one of my previous guests a hard time about it.
GIF makes more sense to me, but GIF, I guess maybe we give him some degree of, I guess if you discover a plant, right, you get to name it. Maybe if you do that, you get to, you are a planet, you get to name that. I don't know. I mean, I don't know what the rules are, that sort of thing.
You get to decide how your own children's names are pronounced, I suppose, huh?
Yeah, that's right. That's right.
Well, Judge, it's been a pleasure having you back. Thanks so much for coming back on the show.
My pleasure. Thanks for having me.
Sure to catch next week's episode of the Lawyerist Podcast by subscribing to the show in your favorite podcast app. And please leave a rating to help other people find our show. You can find the notes for today's episode on lawyerist.com/podcast.
Lawyerist Podcast is produced with help from Lindsay Calhoun and edited by Paul Fisher. The views expressed by the participants are their own and are not endorsed by Legal Talk Network. Nothing said in this podcast is legal advice for you.